Welcome, everyone, to the roundtable on Indigenous constitutionalism. My name is Yves Winter. I'm a professor of political science at McGill University, and I'm extremely excited to introduce the three speakers of today. Our first speaker is Aaron Mills, who received his JD from Toronto, his LLM from Yale, and his PhD from UVic. He is an Anishinaabe from Couchiching First Nation in Treaty 3 territory, who has spent much of the last 13 years learning about Anishinaabe law in Anishinaabe communities and on the land. He joined McGill Law as an assistant professor in 2018 and as the Canada Research Chair in Indigenous constitutionalism and philosophy. As a community engaged scholar, Aaron works with Indigenous individuals, communities, and organizations to revitalize Indigenous law today. Our second speaker is Yann Allard-Tremblay. He's assistant professor in political science at McGill University, and his research interests are on the decolonization and indigenization of political theory. He's a member of the Huron-Wendat First Nation. Our third speaker is Christa Scholtz. She's associate professor in the Department of Political Science at McGill University. She was born and raised in Treaty 6 territory in Edmonton, Alberta. She researches and teaches in the areas of settler Indigenous politics and policy, in comparative and Canadian politics, constitutionalism and federalism. And her work has appeared in the Canadian Journal of Political Science, the Canadian Journal of Law and Society, and the University of Toronto Law Journal. So please join me in welcoming these three speakers. And I'm very pleased to turn over the baton to Aaron. Aaron, go ahead.
Hello, my dear relatives. You can hear me okay? I see, yeah, okay, great. So I'm delighted to be able to speak briefly today and to be on this panel. My intro says I'm from Treaty 3, and I always acknowledge my teachers, first and foremost, my grandmother, Bessie Mainville, Harry Bowen, Sherry Copenhace, Fred Major. And I joined in a spirit of gratitude today, and I'll jump right into it. So I wanted to sort of pick up on the legal pluralism theme, helping to organize our dialogue in the event. And I thought it might be helpful if I try to sketch out two conceptions of Indigenous law, my field of work. One probably familiar to most folks, reconciliation today, from the second sketch, which I think challenges the relatively orthodox position that legal pluralism is normative, that at least some version of legal pluralism is how we ought to organize Indigenous and settler peoples today. And I want to encourage folks rather to take the prospect of incommensurability seriously, and then to think what that means for organizing our relationship. So the first conception of Indigenous law that I hope is relatively straightforward to apprehend because of its familiarity holds that the kind of difference which jurists and theorists need to understand and account for regards how Indigenous peoples do law. So it assumes that the kind of difference that Indigenous law presents attaches really just to Indigenous and not also to law. We Indigenous peoples do law in the familiar, generally understood sense. We just do this familiar thing in an unfamiliar, that is, an Indigenous way. So this familiar propositional sense to which I refer, law means legal norms. And so to invoke law is to refer to a set of kinds of normative propositions. And each of those varies in the degree of determination that it imposes. And there's certainly dispute about this, but in order of increasing determinateness, something like value, standard, principle, and then of course law's paradigmatic form, rule, might be put forward. And of course, rules are often sufficiently determinate that they cause an entire legal proceeding to cut one way over another, whether a rule is followed, distinguished, or a novel one is generated and applied. And at least within the common law tradition, that law means this set of kinds of normative propositions is axiomatic. So even someone like in Quebec here, Rod MacDonald was quite famously invested in the informal, implicit normativity of everyday interaction as producing of law. But even he saw law as, quote, a regime of rules and relationships, end quote, and also as, quote, the means of relationships discovered and nurtured under a just framework of rules, end quote. I mean, within general jurisprudence, the inquiry which has taken up arguably the most space regards the sources of authority, which are said to legitimate specifically legal norms. That's what's centrally at stake in the Rod MacDonald example, but also I think in the decades spanning positivism natural law debate. So for most of us with formal legal training, whether legal norms as a way of thinking about law isn't a question which really comes into view. Now, a conception of law that treats law as a set of propositions presumes naturally certain kinds of institutions, those which generate, interpret, and enforce legal norms. So in Canada, as in liberal democracies around the world generally, we've separated these into the three functions, legislative, judicial, and executive powers, respectively. And if we think of Indigenous law in this conventional propositional way, then the thing that jurists must understand in order to apprehend it are the unique sources of authority which legitimate it. So once more, the view that what's different is the indigenousness of law and not Indigenous law. And it seems to me that on this view, there are obviously practical difficulties, but I actually don't see any conceptual challenges fatal to the prospect of legal pluralism. So this kind of legal pluralism isn't asking a legislature or a judiciary, at least not in any fundamental sense, to challenge how it thinks. Certainly asking them to push their limits and expand their horizons, but I think that's mostly a matter of opening up to more substance within law. So courts, for instance, would retain their existing conceptual starting points, procedures, legal taxa, mode of reasoning, even kinds of outcomes, and simply adapt themselves to account for the new realities of Indigenous law. This way of imagining Indigenous law keeps the existing, in Canada, Canadian conception of law and its institutional framework as is, and would join in. And this would obviously cause some readjustment, and it isn't hypothetical, it's happening. So it is causing readjustment. And the scale of that could easily feel transformative, but the scope doesn't alter the nature of the existing enterprise. It isn't different in kind. So if we think of Indigenous law in terms of legal norms, and so then if we understand that the thing which renders it Indigenous is having unique Indigenous sources of authority legitimizing it. So for instance, a law passed by an Indigenous community, perhaps even a band council resolution under the Indian Act would count, then arguably that's something that Canadian legislatures, courts, and administrative bodies can be adapted to do. But, and it's a heavy but, there are many Indigenous folks, notably elders, knowledge holders, and medicine people, but also ordinary community members, for whom the account just given inadequately captures their own sense of the task of articulating their systems of law as they understand, teach, and act within them. And that's very much what my own experience in Indigenous communities over the past roughly 13 years that I've been trying to learn about our own traditional systems of law have shown me. This propositional conception of law can't capture what they're trying to share. So those I've been blessed to work with in Treaty 3, throughout Manitoba, and in many other communities across Turtle Island have taught me something that was quite a challenge for me to learn, but it's that substance can't be separated from form into generalized propositions when we're talking about law. Rather, Indigenous law must be accessed from within the form of the story, the dance, the song, the elders' teaching, dream, ceremony, petroform, or the earth itself, which holds it. So, and those understandings were disclosed to me by having me being required to enter into experiences, right? They weren't just sort of said to me. I had to come to understand it through ceremonies or teachings, being on the land. And so what I came to understand is that to engage seriously with Indigenous, or in my case, Anishinaabe law, in this second sense, I can't reduce it to a set of propositions. And that's because, on this view, unlike the first one, it isn't just the indigenousness of law, which is distinct, but rather, Indigenous law offers an altogether distinct conception of law. Now, it has unique sources of authority, to be sure, but on this view, those are just one part of a much larger picture of what jurists need to apprehend in order to access it. So what defines this second conception of law is that it arises from within a uniquely Indigenous sense of legality. Obviously, I can't begin to unpack that in my 15 minutes. What I can maybe hope to do, though, is introduce 4 elements of it that I found analytically useful, and then in just a cursory way, address the first 2 of them. And I'm hoping that will be sufficient already to show, to present a serious challenge to legal pluralism. So in short, instead of an abstract and externalized set of propositions directing my behavior or enabling me to form plans, like a code or a judicial decision, I draw from 1, an internalized repertoire of source material, things like legends, elders' teachings, etc. 2, to form judgments. 3, about how to act responsibility. 4, given the relevant context. So to begin to unpack, again, just those first 2 elements. The first one, internalized repertoire of source material. So these are precisely the kinds of things which my grandmother, who I mentioned, and so many other elders and medicine people exposed me to. Things like our sacred stories, Atsokanan, personal and family stories, the Bajamoanan, earth teachings, Akinumagewin, elders' teachings, Ijatwawanan. So I spend time learning these things, and then I carry them all inside, right? All those experiences and what I took from them is like a bundle that I carry with me. And folks like myself who have this privilege are exposed to substantive knowledge in these myriad contexts, and we internalize it. Vitally, note that the normative content of each of these sources doesn't stand independently of its form. So I'm not now carrying around a series of rules like a code inside. Unlike legal norms, which come, as I expressed, in various degrees of determination, they're entirely undetermined until someone interacts with and learns from them. And of course, each of us may take something different. Now, just briefly, the second element, to form judgments. So the resulting output judgment is too fleeting to be a norm. It really doesn't have a life beyond the context of its immediate application, which is not to speak of its consequences. And so Anishinaabe law, then, is something like a deliberative process, an action that accesses the source material to result in judgments which are informed by the third and fourth aspects, which I can't speak to today. And I hope this is already enough to show we're a long way here from general propositions. Neither the relevant norms nor their appropriate application under the immediate kind of circumstance are ever determined in advance. Instead of legal norms, we have something like reasoned normative discernment. Discernment, right? Laws and understanding on this second conception we work towards rather than a proposition to apprehend and follow. And in Anishinaabemowin, the Anishinaabe language, one word for law as a reasoned normative discernment is Inakonegewin. And that's usually what the elders and medicine people, how they'll talk to me about it. And arguably rigor in the key of Inakonegewin, this kind of judgment that comes from inside through these experiences, requires all 4 modalities of reason. So not only mind, although that's very important, but also body, spirit, and heart. We might expect that where law means reason normative discernment and takes seriously all 4 modalities of reason, that the institutional functions of creating, interpreting, and enforcing it are going to look quite different. So for Anishinaabe law, we don't, for instance, find legislatures, courts, or administrative decision makers, but instead, things like Giagashimowin, the vision quest, Makuskewin, a berry fast, it's a puberty rite. These serve to develop the source material, so the first element, and institutions like Atsokewin, which is telling of sacred stories, Maduda Swan, the Sweat Lodge, some folks may have heard of. Those kinds of institutions assist community members in forming good judgments as to what their responsibilities are and how best to realize them. So all those experiences that we often just talk about as culture, right? Sweat Lodge, elders' teachings, those are actually institutions doing law, developing my capacity for Inakunagewin or law as reasoned normative discernment. So what we have here then is two entirely distinct conceptions of law. And so it's not obvious to me in any sense how they could be brought together. So it's not to say that it can't be done. In a separate talk recently, I suggested 4 ways. And I can't do that here, but none of them involves the direct translation, because what we're doing is quite literally pulling something out of one legality and translating it into another. And we would certainly need an argument that it could survive the process. I tend to think rather that it becomes law in the legality that it's translated into. And so I get suspicious and I worry about whether it's assimilating. So I'll stop there. Miigwech, miet. That's it.
Thank you very much, Aaron. And turning over the mic to Yann Allard-Tremblay. Thank you.
Thanks, Yves. Thanks, Aaron, for the great presentation. We actually met before our panel to discuss what we would be talking about. And as you might have understood from Aaron's talk, we have identified incommensurability as being something we had shared interest about. And whether it is the incommensurability of legal systems or of law as expressed here by Aaron, or the incommensurability of what I call the settler constitutional order with Indigenous freedom or Indigenous self-determination and legal constitutionalism. So in my short 15 minutes, what I want to discuss with you are, in fact, a set of related concerns. So it's not a complete paper. They're more like related concerns to the incommensurability of Indigenous self-determination, freedom, and constitutionalism, legal constitutionalism, and settler constitutions. So the first thing I'm going to discuss is what I call the settler constitution, before bringing in the idea that consent is required. And yet I'm going to turn to the non-reductive features of Indigenous self-determination to emphasize the primacy of struggle, and then to highlight in the end how change is not sufficient, but what is required is transformation. And so one of the fundamental problems we face in Canada when we want to think about Indigenous and settler futurities, so what the future is going to be, is that we have one set of institutions, that we associate with Canada, the Canadian Constitutional Order, the authority of the Crown, the sovereignty of the Crown, the title of the Crown. All these institutions that are interrelated are premised on the erasure or the displacement of Indigenous peoples as distinct political entities with a fully uncompromised relationship to the land. They're also premised on the disavowal of any illegitimate proceedings in acquiring dominion and sovereignty over this territory. It's true that Canada has sought to make place for Indigenous difference in its constitution, notably with Article 35, and there's processes of reconciliation and of land claims. We recognize Indigenous rights, there are treaties, and there are processes, as I said, to raise issues about land claims. But none of these undermine the perfect title of the crown. None of these fundamentally undermine the underlying sovereignty of the crown. And none of these truly give the land back to indigenous peoples without also securing settler futurities, right? Without also securing the continuity of the title and sovereignty of the crown on these lands. And it's important here when I say settler futurities to make a distinction between settlers and guests, right? I don't mean that all people who are non-indigenous are settlers. A distinction can be made in terms of the relationship that is entertained with indigenous peoples. For me, settlers are those who know that they are on indigenous lands and refuse the responsibility that comes with it. And so in the Canadian context, the recognition of indigenous difference has been understood generally as a process of reconciliation with the sovereignty of the crown. The sovereignty of the crown is not under question. Indigenous peoples have to come to terms with the existence of this perfect title and dominion. So the point I'm making here is that when we're seeking a common future for Indigenous peoples and for the settler state of Canada, well, this is a process that requires sacrifices. Either Indigenous peoples will have to accept a subordinated status and relinquish their own sovereign claims. And it's important here to note that when I say their sovereign claims, I'm using sovereignty strategically because it's easy to appeal to, and I think that Indigenous understandings of their relationship to the lands and of authority is more complex and different than sovereignty, but I mean, it works. We can use it strategically. So either they have to relinquish their sovereign claims and accept their subordinated status, or it's the crown that has to accept to give up on its sovereign prerogative, on the supremacy of Parliament, on its dominion over the territory. Well, the first option is assimilation, not reconciliation. And yet, this is the one that is on the table for Indigenous people. And the second one, well, is unpalatable to the Crown. It's not something the Crown wants to do. And so, the settler constitutional order, that of the Canadian Crown, is incommensurable with Indigenous freedoms. There's an inconsistency in how it has been considered. Yet this doesn't mean that we're not trying to address the issues. One thing that is considered in Canada is to implement the United Nations Declarations of the Rights of Indigenous Peoples, which would institutionalize, which would require us to institutionalize a form of robust, free, prior, and informed consent for issues that would affect Indigenous rights and Indigenous lands. I'm not going to detail what free, prior, and informed consent requires. I invite you to look at the Yellowhead Institute paper, red paper on the land back, where they provide a very good account of what a robust account of free, prior, and informed consent would require. My concern is that Canada has been content to see its consultation process as satisfying consent. That's a process where Indigenous people cannot say no. And yet they say that it meets the requirement of free, prior, and informed consent. And as I've noted every time I've talked about free, prior, and informed consent, can you really have consent if you cannot say no? The issue here is that consent would be a form of veto, which is the great fear of settler institutions, because that would fundamentally undermine the sovereignty of the Crown, the sovereignty, the supremacy of Parliament to decide how things happen over its territory. Enacting free, prior, and informed consent would require, in fact, rethinking our constitutional order in important ways. And yet, free, prior, and informed consent is only a minimal requirement in order to implement the UNDRIP. And when you look at it, free, prior, and informed consent is in fact concerned with things of internal concerns for Indigenous peoples. By only focusing on free, prior, and informed consent for internal concern, we also risk consolidating the status of Canada as supreme, rather than as a partner, rather than as a brother or sister with the crown above both Indigenous peoples and the crown's other children, the newcomers, to borrow from Ash's reading of the numbered treaties. And so the further risk that we have here is that UNDRIP and free, prior, and informed consent will require implementation. They will need to be given a legal form in the Canadian legal context. But the risk here is that this will reduce Indigenous self-determination to its legal form. Its legal form will appear as the legitimate expression of Indigenous self-determination and as setting limit to this self-determination. But Indigenous political authority and political difference are sui generis. They have their own foundations. They have their own mode of expressions, as Aaron clearly explained. They have the authority to determine the scope of their own authority, such that their authority cannot be reduced to the legal form they would be given in the Canadian constitutional context. UNDRIP and free, prior, and informed consent cannot be seen as capturing the full extent of the legitimate expression of Indigenous self-determination. To put it differently, Indigenous sui generis authority always exceeds the legal forms they are given. But in a context of accommodation with the settler institutions of the Canadian states, their legal form may appear as the only legitimate agreement achieved on the extent of this authority. If one of our main concerns with constitutionalism is to protect and institute Indigenous freedoms, well, I do think that we need to heed some of the voices of political constitutionalism. And more broadly, we also need to recognize that, to take from Bernard Williams, in the beginning was the deed. Right? Indigenous freedom is served ultimately by the ability of Indigenous peoples to assert and enact their self-determination within an institution, but also beyond an institution through what Robert Odawi Porter has called tribal disobedience, or what Leon Simpson has called generative refusal. Indigenous disobedience, Indigenous resistance, Indigenous enactment of their freedoms, how ways in which Indigenous people assert their authority and enact their own life ways. They're not illegitimate forms. They are enactment of freedoms, such that struggle and resistance in the face of an inconsistent order, like that of the settler constitution, is itself the affirmation of Indigenous freedom. And this form of resistance obviously cannot be reduced to legal forms, because it is an overcoming and transcending of legal forms. And so in the end, I think that if there's to be reconciliation between Indigenous peoples as distinct peoples with their own laws and their own system and the settler constitutional order, I would argue that the settler order cannot only change. It cannot only reform some of its policies. It cannot only include a form of free, prior, and informed consent. Some of its fundamental and essential features need to be abandoned to make a genuine relationship with Indigenous people possible, and to make possible a genuine return of the land. This requires transformation, not merely change. And here, in ending, I want to quote from Angie Krog in Begging to be Black, where she writes, "The word transformation means to form the other side, to start creating where you are going. But trans also appears in words like transfigure, transfer, transcend, transaction, transgress, transience. In the Dutch, hemeltrans. It means firmament. One could say that in order to create the other side, one has to remake the firmament. No mere change of structure or exterior, but of the guiding essence. Change, metamorphosis, transformation. The latter includes the former, whereas change implies neither metamorphosis nor transformation. And what we need in Canada is transformation." Thank you.
Thank you very much, Yann, for this presentation. Our third speaker is Christa Schultz. Please, Christa.
Thank you. Thank you, everybody. I especially just want to say that it is a great thrill, like a total thrill, to be on this panel with Yann and Aaron. Aaron started by thanking his teachers, and I just want to say that being part of this conversation is, for me, a great teaching. So I thank my co-panelists deeply, and to RGCS for letting me be part of it. It's a big job that we're looking at. And as Aaron and Yann have so clearly and forcefully set out, the question is how to get it done and what it takes to get it done. And my plan today is to make perhaps 3 points, the two of which could arguably be characterized as tinkering around the margins. And the third perhaps goes at least partway to addressing the transformative potential that Aaron and Yann are pointing us towards. But let me work towards that point. So you have to start from where you are. So where we are as a scholar of Canadian settler colonialism is to take on board take seriously on board the eliminatory logic of settler colonialism. That part of this, the essential part of it, is to eliminate from our laws, from even our understanding of what law is, from our structures, from our institutions, the various and rich views and lifeways of Indigenous peoples. So how do you get away from a settler colonialism? Like most things, I think there is incremental change, which is most of what we do. And that sometimes there are moments which allow us to reach towards a transformational change. So I think one challenge is to not abandon one for the other, because we don't have the luxury of doing so. So the first point I want to make is about how to address this eliminatory logic. And I think that a discussion of legal pluralism is necessary as part of this, but insufficient as part of this. The Canadian constitutional structure as it is needs to reach for and understand even the small changes which are possible on this front. So my first point here is to think about our own discourse, I say within the Canadian constitutional discourse of vacuums. And here I'll point to the Templeton decision of 2014. So for those of you unfamiliar, this decision was in its context, in the context of settler colonialism, a very important decision because it is the first recognition from Canadian judicial order of a finding of Aboriginal title, where an identifiable group of people have something that is recognized within Canadian law as Aboriginal title. And yet, so in that sense, a landmark ruling, but in another sense, a very problematic one, because as you read this discussion, as you read this ruling, the court's language is one of vacuums. That if there is a finding of Aboriginal title, and if there is no legislative action by provinces, by the province or by the federal government, that what remains is a lack of law, a lack of a normative structure to regulate that land. And if we are to take seriously at least baby steps towards a meaningful legal pluralism on at least Aaron's first account, it is impossible to think about lands being unregulated as being unembedded within a rich normative structure. There is no vacuum for which the Supreme Court could use to call upon to justify a federalism, a problematic, in my view, incoherent federalism analysis. So this language of vacuum is at least the smallest movement, getting rid of a language of vacuum, opening up our view that even in the absence of state-based law, there is either an Indigenous law on the basis of Aaron's first proposition, or there is, if not law in that sense, then at least a rich normative framework to think about, and that acts in, that always acts underneath. So another point I wanted to make about that decision, which I found interesting, is that at trial, this was a massive trial, 5 years long, where the trial judge went to Templeton territory, engaged with elders. And so in that sense, we could view as baby steps, as movement towards an intelligibility, towards understanding Indigenous systems of law, again, at least on the first proposition that Aaron gave to us. And yet it is understood, perhaps, it is still understood by Canadian law as engaging with witnesses to establish a fact-based account of things that happened hundreds of years ago, rather than an engagement with legal officials or people engaged in an analogous law creating or law generative moment. So even in this landmark case, there's problems, but also indications of moving at least one way forward. So that's the point I wanted to make about vacuums. The second is to talk about, move towards a discussion of Section 35. So Part 2 of the Constitution Act of 1982 was this couple of, in some ways, thin commitments. And Section 35 sub 1 reads that the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. On a thin account of legal pluralism, this is the way that Canadian constitutionalism has now opened up for a recognition of the value, the place of Indigenous law within the Canadian system. And that's been important, right? That Canada has entered into a commitment which effectively says, at least with respect to Aboriginal rights as part of Section 35, that Aboriginal rights are based on Aboriginal systems of law, based on their own systems and understandings of the place in which they live. And that is no small thing, at least within its context. And that small thing has generated a discussion, a jurisprudence, which is reaching towards something, even perhaps awkwardly. There is also treaty rights as part of that constitutional commitment as part of Section 35. Now, as Yann has alluded to, I think that we have thought too restrictively about what that could mean, what these treaties could be about. In the current situation, they are used to constitutionalize modern land claim agreements, and there's a wealth of literature out there that points to the limitations of that approach. I want to encourage us to think about treaties or agreement making as a way of, as at least expanding what treaties could be, to perhaps establish agreements that allow for that constitutionalize some kind of process of legibility making, of understanding, of reaching towards at least that first proposition. We haven't done that yet, or at least we have only started to do that. And my third point that I'm trying to work towards as more transformative, or at least provide some kind of a response to the forceful critiques of Yann and Aaron, is this Section 35 itself. I think that there is transformative potential in how we can think about what Section 35 does in our constitutional structure. I've written in a piece in the University of Toronto Law Journal that I think there is available to us a different reading of Section 35 as not just a clause which constitutionalizes discrete and limited Aboriginal rights or specific and discrete agreements. But that might, a new reading, a controversial reading, one which sits ambivalently in my own analysis, I'll be 100% clear on that, or try to be, that perhaps Section 35 can be reinterpreted as a treaty amendment clause, that we can think about treaties as actually amending the Canadian Constitution, to think about treaties as being a super procedure, as being the place to start on the Canadian constitutional structure. And that this is a totally different way, it's a way of inversing how we think about what the Canadian Constitution is about and the relationship of that Constitution with agreement making with Indigenous peoples. So I think that there is potential there, but it is transformative, or at least I put forth the argument that that potential rereading is transformative. But how we get there is a totally different and wide open story. So I'm not sure what my time is, but I think that's all I actually have to say. So if that means that there's extra time for discussion, then I'm completely and actually prefer to yield my time to my co-panelists and to everybody else in the room. So thank you very much for listening.
Thank you very much, Christa. And thank you, all three of you, for these wonderful presentations. We have about 15 or 20 minutes for discussion on the roundtable before we open it up for Q&A. And I was wondering if I could invite you to respond to each other, and maybe highlighting 3 points. One of the points that each of you made, and see whether you find it productive or useful to respond to each other on these points. So I found Aaron's distinction between two forms or two types of conceptions of Indigenous law, Indigenous constitutionalism, really interesting. And I was wondering whether both Aaron and Yann and Christa, whether you wanted to respond to the question of how they relate to one another. Because on one reading, one might say that these are alternatives, right? These are alternative conceptions of Indigenous law and Indigenous constitutionalism that are mutually exclusive. But on another reading, one might say that they're, that they might be, that in fact both of them might be in play, might have to be in play for processes of resistance or reconciliation, whatever you want to call it. And I'm interested both in how Aaron thinks about this, but also how Yann and Christa, how you would conceive it. And I'm also wondering how Yann, the two kinds of Indigenous freedom and self-determination you map out. On the one hand, Indigenous freedom and self-determination as sort of like the imminent goal, the imminent objective of Indigenous constitutionalism, and on the other hand, Indigenous freedom as a type of resistance, right? As a type of resistance to dominant settler constitutionalism, how you see them as relating to one another, and also how they relate perhaps to Aaron's distinction between two types of Indigenous law. And finally, I'm curious about how each of you responds to Christa's argument about Section 35 and its transformative potential. And I'd be very curious to hear, both Yann and Aaron's view on this in particular. To what extent you share, you share this sort of like complex, but ultimately also somewhat optimistic reading of Section 35 as having this transformative potential.
I guess I'll just throw the idea that's kind of rattling around in my brain. To the question on Aaron's two conceptions as he's laid it out, how do they relate to each other, and how does a Canadian constitutional structure, what's the best way to address how to move forward while also respecting the kind of deep level of difference that Aaron is pointing to, right? Is any effort at translation, is any effort at intelligibility or legibility, whatever the word is that you want to use, is engaging in that intelligibility mapping actually harmful to whatever's going on in that second conception? And I think that it's a tension. I'm not sure that can be resolved at all. I think that in order to move forward, this intelligibility exercise is necessary. I don't see how you go forward without it. And yet I need to hold seriously the view that they're like, that's fraught with danger, that is fraught with difficulty. And yet I think we need to move forward despite that, or in the face of that, or being cognizant of that. So I have, in sense, I just want to say, I think I understand the difficulty, but I am horrible at trying to provide a way for like an actual answer to how do you do that well. And I'm not sure there is one. Just that it's a tough one to wrap your head around.
Aaron and Yann, did you want to respond, or did you want to open it up to?
I was letting Aaron's answer, since it was a bit more on his topic.
I was letting Yann go first. So shall I just go ahead then, Yann? Okay. So terrific questions. Thank you very much for those, and very much appreciate the talks of my two colleagues. So this is a deeply challenging question, one I've sat with for quite a few years now. I really take to heart Christa's point about we have to start from where we are. And so that's something I've really wrestled with, right? I'm always very clear that in presenting the second conception, I'm not a purist thinking that, we can approach this in an ideal sort of way. It has to be in the mess and the muck of how it is, which is badly compromised for the reasons Yann explained. Mm-hmm. So for me, I guess, there's sort of a big, not a debate, because they're not really in dialogue with each other, but we do have both perspectives in the literature that engaging in a sort of reformative way, deliberately privileging engagement with state actors will yield something transformative. And I think of John Borrow's work in this way, although of course that's not to say that he would represent it that way himself. And on the other hand, a rather emphatic account that the latter does not follow from the former, Glenn Coulthard, that all that can happen is capture. And Gordon Christie also has written about the liberal snare in that sense. And so both perspectives are certainly out there. For myself, I worry deeply, to sort of put this in the discourse of constitutionalism, that what happens when we flip legalities is we are quite literally reconstituting law from one conception into the other one. And so I'm not, for me, I'm not a keen supporter of intelligibility in the sense of direct translation, because I think of it as a hostile and particularly a constitutional takeover. But that doesn't mean that I think there's no space. So I actually put a lot of effort in my professional life into trying to explain this other side, because I just see so much benefit, including to institutional actors, right? To judges, to policymakers, to administrative decision makers, to NGOs, public service. I think right now the problem is that essentially nobody sees the other side. Like it's mostly that they don't even know it exists to ask about it, that second conception. And so my hope is that by engaging in sort of educational efforts, it will sort of slowly come to be disclosed. Folks will learn more. I'm always express in my talks that it's not just for Indigenous peoples to know about it, that it's for everyone. I think that was the whole point of treaty. Maybe the last piece I would add on this, which is maybe also my answer to the question about Christa's point. I mean, ultimately, to me, the answer to the incommensurability problem is treaty, and but not in the liberal sense of independent autonomies transacting according to their rational self-interest, right? Like it's in the sense of that the words Yann used, brother, sister, right? That's the discourse of all of the like inter-Indigenous treaties. And the archival record is replete with that language. All of the petitions, the early treaties, etc. Wonderful scholarship on the significance of those terms, including when they're from parent to child, and how that does not connote a lack of sovereignty, again, to use it in Yann's strategic sense. And so Mark Walters in particular springs to mind there. And so it's treaty, but in the sense of actually relating to one another and even needing one another interdependently. And so, you know, entirely outside the allegory of contract. And that's much, much harder work than legal pluralism, because it's to allow the different stands all the way down. And so it's extremely difficult, but I mean, to avoid the kind of violence of constitutional translation, I'm not sure what else there is. So also, you know, prior to colonialism, as Indigenous folks, that's how we always did things. So, you know, we've got a long history of success in building confederacies. So that's it. It's more of a confederal than a federal model. That's it.
So if I can jump in on the questions. So I'm not a legal scholar, and my work is more in political theory, and I'm interested in how to think about political norms and transformations that are required by Indigenous practices and Indigenous political thought. And I really appreciated the point made by Aaron about the incommensurability, or the different ways of understanding norms and right behavior, because this idea of what we could call embodied cognition and epistemology is central to understanding, not just in terms of law and constitutionalism, but also how justice is thought about. So what is the right in a political society is also completely changed once we understand the centrality of the various elements that Aaron brought up. So for instance, in Iroquois political thought, being of one good mind is central to making political decisions. But that requires a process. That requires the Thanksgiving address, where you thank all the elements of creation. This is not my tradition, but I've witnessed it, right? And that, as I write in one draft work that I'm working on, this is a political technology, and it has a purpose for making decisions together, but it's embodied in this practice. And I think that's can this be translated? I think that's a different question, but I think we can. There are ways of understanding where, as I like to call it in my work, where there's a disjuncture, where there's a completely different ways of doing things that are related, but that do not go in the same direction. so I don't think they're mutually, I don't think they're unintelligible, but I think they're definitely different paths. But that's at least in terms of political thoughts. For law, I'll leave Aaron provide the answer. And as for Christa's point about section 35, maybe there is a more transformational reading, but also section 35, article 35, though it's in the Constitution as being read as being infringible, right, for public concern issues. So its constitutional status is not that of having the rest of the legal system being in agreement with that supreme article, right? It has been downgraded. So yes, if it had that role, maybe it could be transformational, but there is extreme resistance. And I mean, just with the Niskaha treaty, the Senate was very reluctant for the word citizenship to be used to describe the citizens of the Niskaha nation. So there is potential, but I think this resistance is still there within the institutions of Canada that would need to be addressed in order to move more towards this joint relationship, as Aaron noted, how treaties can be partnership and not mere contracts.
Can I just say here that what I offer is definitely an alternative reading. This is absolutely not the reading as currently understood by the Supreme Court at the very least, or by, well, anyone really. And it's mentioning its status as an alternative reading is not at all a way of saying that this is currently politically feasible. I just wanted to kind of put the alternative on the map as a possibility. Whether people reach for it or not is a completely different and deeply political question.
Great, thank you all. I'd like to open it up to Q&A and discussion with the audience. So we already have a queue of questions. If you want to ask a question, I invite you to use the reaction button, excuse me, at the bottom of your screen, and the raise hand function. So Arash, go ahead.
Yes, this is a question for Aaron James Mills. So when you were describing the second alternative, I'm trying to translate it into sort of the things that I know, and we can talk about whether that's okay or not. But in trying to understand the way that you're describing the second alternative, I guess that the thing that kept striking me was the similarities that I see in moral philosophy, the way that people talk about moral particularism. So, there's this debate about moral generalism and moral particularism. Particularists like Jonathan Dancy, they argue that there are not moral principles that are articulable in propositions, and it's your reference to propositions that really sort of getting me thinking about this. That there's not moral principles articulable in propositions that count as reasons across different contexts, that whether or not something counts as a reason for action in different contexts is always dependent on the larger sort of holistic consideration of the context and situation. So there isn't this kind of principle that even pro tanto counts as a reason across different contexts. So that's in moral philosophy, but it seems to me like if that's a fair way of understanding what you're describing, that you're then taking that a step further, which is not just to characterize ethics or moral philosophy in this way, but to characterize law in this way, in this particularistic fashion, so that it's not articulable in principles that could be applied across different contexts, but it depends on the judgment of individuals who are embedded within particular practices. That's how I'm understanding the way that you're describing Indigenous law. And so I guess my question for you is related to the issue of incommensurability that you brought up, because My question is, I'm trying to wrap my head around how it is that a system of law, if I'm understanding it properly, that is supposed to be particularistic in that way, how it could function across to regulate the interactions between people who don't share a thick sort of ethical life together. So how is that how is a system of law conceived in that way going to function in a society where people where there's this kind of pluralistic cultural diversity, if you like, or ethical diversity, even. And so that's one way of asking the question to you. And then the reason why I think it's related to incommensurability is because if you like a generalist who thinks that there are articulable propositions that can be codified in a legal system, will have an answer that says, well, that's because we don't expect of different actors to share this thick cultural heritage together in order to be able to coordinate their actions with each other. Because what we do is we don't rely on a conception of the good or ethical, a thick ethical tradition, but rather we rely on norms that are understandable to actors and therefore not incommensurable across different traditions. They're understandable to actors in virtue of their articulation in these kinds of propositions. So I don't have to, I don't have to share like with my Hasidic neighbors, like their traditions and so on, but I still nevertheless know how I'm to interact with them given certain kind of social norms and so on. So I guess my question for you is, am I understanding, what you're describing for us in the second alternative properly? And if not, how am I getting it wrong? And to the extent that I am understanding it properly, how can that kind of conception of not just ethics, but of a legal system help coordinate action in a context of diversity, if you like? How is that going to function?
Okay, Miigwech, thank you. What a terrific question. There are too many things I want to say. I won't be able to say all of them. So I'm also interested, maybe we could chat further after. What's the positive project commensurate with moral particularism? I'd like to hear about that. So one piece is, amazingly, I think we have very strong evidence that this actually has worked, in fact, across communities on Turtle Island. And so quite distinct cultures, entirely different language families, Algonquian, Iroquoian, Siouan, managing to form relationships, sustain them through conflict. Again, not ideally, right? Often it breaks down and then gets reformed. But I think the thing that explains that possibility, and which is a profound challenge for the world we live in today, is that despite all of the sort of substantive difference, different creation stories, different teachings, different ceremonies across all these different Indigenous societies, what they all shared in common was the same kind of constitutionalism. So distinct constitutional orders, but all of one kind. And it is different in kind from the liberal form of constitutionalism that characterizes and enables a certain kind of difference today. And so this is sort of a way of saying a deep commitment to earth, not in terms of like substantive norms, but as a way, as a means of constituting and continuing to constitute oneself as community over time. Actually, I think it's fair to say is pan-Indigenous in the good way, right? Not in the kind of pejorative. And so this is what treaty was supposed to be, right? As the elders have taught me, and as I believe, we welcomed European and now many other folks in, but the understanding, which turned out to be deeply misguided, was that they would do so on the same foundational connection to earth. And so that we would all experience the great multiplicity of our difference together on a shared understanding that Earth leads. And so we would constitute ourselves as sort of microcosms within Earth's own internal legality. So the second conception, that's where it comes from. If we were to track the legality all the way down, and I just offered the top two levels today about sort of law and then institutions. But if we were to look a sort of the justificatory train down, and then look at constitutionalism, and then ultimately life worlds, that word someone used today, this is what we would see, that they all do this in different ways, but that the constitutional orders are all of one kind. And so it's when we cross that kind that there are serious differences. So the other piece of the answer that I want, and I suspect that raises more questions than it answers, but the other piece that I want to say is that, whenever I sit in ceremony or in community, Indigenous communities, there's usually an explicit statement that, folks from whatever their substantive, maybe it's a faith tradition or a thick sense of culture, are welcome. And so when we go into a sweat or a turtle lodge, a place that means a great deal to me in Sa King, Manitoba, the center of Turtle Island, they're express about welcoming in everyone, right? And so the sort of sense of normativity that comes from this is meant to allow for deep difference. And part of the, you have to be careful because this will spiral quite quickly, but our sense of constitutionalism does not have a centralized government. So we don't have constitutionalism in the juridical sense of power that constrains legitimate governmental authority. And so there is no sense of normativity imposed from above. We work it out between families in our ordinary interdependent relationships. So it's thick, it's real, but it's not, the worry of imposition from above doesn't arise in the same way. There are lots of other worries. Again, it's deeply imperfect, but anyway, 2 points by way of response. Happy to chat much more afterwards. You want to follow up?
Thank you. Catherine?
Hi, thank you all very much for your great talks and great Q&A. So my question builds a little bit off Arash's, and I, like Yann, I'm also a lowly political theorist and do not know the legal stuff as well as Aaron. But my question is about actually international law and international order, because it does seem to me your talks mainly have focused on Canadian constitutionalism, and it sounds like some of you argue for some kind of radical transformation of that, but of course Canadian constitutionalism cannot exist by itself. It's part of an international legal order that has actually codified the sovereign rights of the state as a supreme authority over a given territory, over a certain people, et cetera, right? So I guess my question to you then is what you think about the relationship between this international foundation, really, of any state sovereignty, right? And what can be done at the Canadian level, right? We just saw the Supreme Court of Canada say that the Sinixed people are not extinct and that their people can have transboundary rights. That does seem to be a challenge to the prerogative of states to exclude people who are not citizens based on Aboriginal title, right? So that seems transformative in terms of recognizing transboundary Indigenous people self-determination. That could have radical implications, but it is still the Supreme Court of Canada that that made that decision, right? So I guess I want to know at what level the transformation has to happen, and if Indigenous activism at the international level, for example, with UN DRIP, whether you see that as a kind of necessary simultaneous political effort that would then also perhaps help the sort of Canadian case, which in a way, I guess perhaps makes the struggle for Indigenous self-determination even more daunting, but in a way, I think it might be more accurate, right? That's necessary before, or at least to coincide with any Canadian changes. And then the final thing I wanted to add was I really enjoyed how you added in the perspective of Indigenous peoples on Earth, like on coexistence on Earth, because perhaps the basic reason why I think this needs to be pursued is not only Indigenous self-determination, but we're in the era of climate change, and perhaps this what we can see now is that this model of sovereignty, of territorial sovereignty, that really historically has only really been in effect since World War II, right? It started really after World War I, but it's historically not at all a long living thing, and it's obviously not sustainable. So I guess to me, the struggle for Indigenous ways of thinking about constitutions and the way that humans relate to the planet actually is incredibly important for everyone and not just for Indigenous peoples, although obviously fundamentally important for them as well. But if you can say something about that, I would really appreciate it. Thank you. For all three of you, I'm glad to hear from all of you.
I'll respond, but if my colleagues have something, I just spoke a fair bit. I'm happy to let them speak first.
I don't have anything to really contribute on this one. Waiting to hear what you guys have to say.
I'm happy to go after.
I guess a couple of points. This is the point where I always start to feel bad because I'm like the naysayer guy. But you know, much of my worries apply in just the same way, and so it's the same kind of, I mean, if we understand how the sort of, you know, the League of Nations and how international law as it's currently constructed has its sort of history, a lot of the same life world, again, if I could use that word, informs it. And so a lot of those same presuppositions about autonomous bodies and, you know, freedom in terms of negative liberty and contract, and this makes its way into many of the instruments, right? So one of the much maligned clauses of UNDRIP, for instance, is the one that says that any of the stuff that's happening here that we're really proud of is not to impair the territorial integrity of existing nation states. So there's a sort of a clear moment, right, where it breaks through. And so much of my worry just applies in the same way. I think there are many folks, many of them friends of mine, who are making brilliant strategic use of international law in Canada and elsewhere. I think it allows for more creative possibility, and there's more opportunity to bring in some of the second conception that I've, in a very, very cursory way, tried to put forward today. So I don't mean to you know, speak ill of it, but the same sort of underlying conceptual worry exists. The other thing, you know, to really push forward that register you were connecting with about Earth and climate change, I mean, that's sort of the deep worry, like the pushback this second conception offers ultimately isn't about, it's not ultimately sort of driven by the idea that the ends of political community are different than they are under a liberal system, which I think is true. They're not justice, actually. It's some harmony, but a particular conception of harmony. But it's more about the starting point. Like the sort of ultimate goal is more life. And I actually have no hope, to be, you know, really transparent and honest, that any liberal conception of political community can get there, because almost by definition, it doesn't incidentally, it necessarily fails to internalize the costs that have resulted in global warming. And I'm not sure how, like on a theoretical level, I'm not sure how it could rise to it. And so practically, I'm not sure how it could find the resources to address that. And so, you know, part of, like, if your sort of grund norm is a position of disconnection from the other, and it's about our choice to connect in various ways, as opposed to being always already inextricably bound up in the other, it's pretty hard to avoid the externalities problem. And so, you know, part of my hope is that, I mean, again, this is what I think treaty was intended to accomplish. What I would call the rooted form of constitutionalism is open to everyone. And I think it's practiced by Indigenous peoples all over the globe. And that fact is not incidental. Like, there's a very good reason why that's the case. And so I hope, to invite everyone to participate in that. And so ideally, there would also be a different kind of international order, right? One where we take our connections with one another sort of really seriously, and not just in a neoliberal kind of way where it's about like the material connections, but much more profoundly.
Catherine, you asked at what level has the transformation to happen, and I think that it is transformation is not in one area. Transformation is not change. Transformation is more than metamorphosis. It is a complete change of structure and of substance. Our current system and life ways that we've inherited from, well, modernity / coloniality is grounded on certain fundamental ideas such as sovereignty, mastery, and possession. And we, as Descartes said at the dawn of modernity, with this method, we could make ourselves like the lords and possessors of nature. And that's how we've been behaving as masters and possessors. And that is not a grounded or rooted constitutionalism or theory or life way. It's one that sees the world out there as there for our purposes. This outlook needs to change, but it also, like, it's not just a substantive theory. It's one that informs political and social relationships. There are examples like the dish with one spoon. It's not a treaty of which my nation is part of, but it's an imagery that has been used by chiefs of my community when speaking to the National Assembly in Quebec. It has a long history, and it affirms that we're all eating from the same dish with one spoon. There's no knife with the dish, and so it's a peaceful relationship to share the lands together and to leave enough for others, and not in a Lockean sense. This rooted and grounded constitutionalism Aaron is talking about really informs fundamental changes in how we relate to one another and to the rest of the world, including non-humans and the land. So, like, that transformation is deep. And I do think it has the potential of maybe addressing some of our concerns about climate change. Whether it be enough is a different question, but it's not the path on which we currently stand that will achieve that.
Thank you. The next question is from Ryan.
Thank you. And thank you for everyone on the roundtable. So my question is for Yann. I think you made really good points about the enforcement of settler institutions, from classifying Indigenous metaphysical beliefs as religion or purely cultural, along with like enforcing things like nation states or even the state itself on them through institutions such as treaties, or requiring them to, or requiring conception of them as citizens. Where I begin to disagree or maybe not understand is that I don't see a way of resolving conflicts in metaphysical descriptions, if not through some rational battleground, for lack of a better word. I'm not using language very well here. Such as, I see the idea that different rights have different metaphysical conceptions, such as that the liberal order does see beliefs in property, see beliefs in individualism as completely concrete. And so to say that Indigenous people's beliefs are not, able to challenge them is a form of cultural imperialism. But I don't see how you can create a system that can debate those beliefs, if not through some some system that does not tip hand one way or the other, such as if you have beliefs on the value of animal life, that like a vegetarian or a vegetarian would argue that an animal has the exact same kind of value, or has like a pardon me, or to do an example, maybe one believes that all living things have souls, and so that killing a soul is always bad. How are you able to argue that without either saying one is correct and one is not correct, or by appealing to some unworkable ability to say only people with similar beliefs can exist in the same constitutional system?
That is a difficult question. But is the purpose of convincing rationally, or of a leap of faith, in a sense, of changing the ways you do things? Because as Aaron explained, when you engage, it's a different practice, not merely a different belief. So I'm wondering if how do you move from practice? What you're saying is, how do you engage in that practice as if it was a belief, but it's not merely a belief, right? So it's not about convincing. And if the convincing happens, it's not through that form of rational engagement. And I'm thinking here of a conversation I heard Sakesh Youngblog Anderson giving at a conference, and he was saying that repeatedly he was asked, so what is Indigenous law, right? Could you give us a list of what is required? And he said, no, I can't. You have to come with me into ceremony. And in a sense, that's the convincing. It's come to ceremony, learn the life way, rather than me giving you the argument for why animals should be considered in relationship with us. What I can do, though, is point to the detrimental consequences of that life way and the current path of ecological ruin on which we're currently following. But that's part of the incommensurability. Right? It makes it difficult to talk to one another, though I don't think it's impossible. I just think it's not the same. It's not the same terms.
Oliver?
Good morning, everyone. I hope that you're well. It's good to see all of you. I guess I sort of wanted to organize my thoughts more so towards Professor Schultz, and I guess I'll sort of just provide a bit of an example of where I'm going with this. So recently, Quebec had declared the Magpie River as a legal person, and in as much as it's now considered a legal person, it possesses a patrimony. So it possesses a bundle of rights that are purportedly informed from, I guess, Innu customs. It includes a right to flow, right, and maybe a right against, to be safe from pollution, but also includes a right to sue. And I guess sort of my thoughts are as follows, right? Because on the one hand, this model doesn't depend on, a settler colonial fiduciary actually weighing the interests, right? What can happen is that the traditional custodians of the land are able to sort of sue if any of these rights are breached against, I guess, the government. But these claim rights have to be, put forward to a settler colonial court. And I'm sort of wondering, I guess, how optimistic you would be that a court would be able to grant relief and sort of recognize these rights. Because I guess one just obvious issue is that in the Civil Code of Quebec, we don't see, I guess, natural. I guess we lose that in translation. we don't think of, I guess, natural things as possessing patrimonies, but so this is like quite a novel change. Sorry if that wasn't entirely clear, but I guess it relates to, I guess, Delgamuukw and Chilcotin in that sense.
Thanks for the question, Oliver. It's really good to see you. I hope you're doing really well. I'm actually just want to say that I'm pleased to hear your question, because when Aaron was speaking, I went legal personhood, and then I was listening more to what Aaron was speaking. I went, oh no, I don't. Right. So I think this whole idea of legal personhood is a way around, or a way that is kind of the liberal answer to the liberal answer, the way of giving a river a corporate form as the way that is commensurable with our understandings of law, that this is going to get us where we need to get us. So first of all, this is where my own inability to get enough reading done over the pandemic will show itself. I find this a fascinating direction, but I do want to reinsert it within what Aaron and Yann were saying, that if perhaps the solution isn't more liberalism, and that perhaps the real solution is to step outside of it. But given liberalism, given liberalism, perhaps it isn't the worst way of thinking about it. But that the harder challenge is that underlying question of why the liberal turn in the first place. So that's just a way of saying I think it's a great question, and I think there's a literature there, and it's one I want to delve in more deeply. But this whole discussion we're having about rooted constitutionalism is the I think a really powerful counter response to that move. I don't know if Aaron would agree or disagree, or Yann, but that's where my mind kind of has gone throughout this conversation.
Thank you. Yeah, I sort of had a similar thought about more liberalism may not be the solution here, but figured I'd bring it up.
I'd like to add one element about this, if I can. So I'm thinking about the land back red paper by the Yellowhead Institute, where they did a extensive survey of injunctions that were requested by industry and injunctions that were requested by band councils to protect territories. And the statistics are clear that injunctions that were requested by band councils were mostly always rejected, while the injunctions requested by industry were almost always granted. So that this dynamic that you're speaking of standing in the courts of the settler state may be at risk for producing itself, even in the cases of like a river being considered a personality and seeking to enforce its right. I mean, that's speculative, but I think there is data on how these injunctions have been granted by the courts, and I think that might be relevant to that question.
We're technically out of time, but I would encourage everyone to stick around. If the presenters, the speakers have a few more minutes, we still have a couple of questions, and it looks like there may be other people who want to get in on the conversation. So if you're all game, I would say let's stay for a few minutes longer. Next person on the list is Victor.
Trying to unmute myself because my computer was updating and I still don't know how to deal with this on an iPad. Yeah, so my question is for Aaron, and I think it's not, if anything, it's just an invitation to a further conversation that I think is long overdue, because I mean, I have a whole chapter in my book on law's intelligibility, and the most important pushback that I've received on that has been precisely from Indigenous legal scholars, or at least scholars of Indigenous law, not necessarily. Now, I think, of course, the first thing that any scholar says whenever they receive any pushback is that you have misunderstood what I said. But in the sense that I've always started from the presumption that law is a mode of governance that is not necessarily superior or inferior to any other mode of governance, but simply has certain modal characteristics that make it different from other modes of governance. And one of the problems, I think, in the Western legal tradition itself is the subsumption of every other mode of governance under law, which means that we lack imagination to think of other modes of governance. And in the approach of the Western legal tradition or the settler tradition to Indigenous law, one of the natural objections that I think has been underplayed, in part because people think law is a good thing, is to simply say, well, what if a lot of Indigenous law is just not the right thing that we tend to talk about as law, but is nonetheless another mode of governance? And this question of intelligibility for me is the problem of very often Indigenous legal traditions of trying to fit these non-legal modes of governance into the box of legality, or perhaps into the language of legality. I remember Kristen Anker talking about the way that business is used in Aboriginal law in Australia. Business was identified as a word that meant a lot to settlers. So things like death rights were spoken of as death business, because then the settlers would take it seriously. So I think that in some sense, there may be a shift which results in a lack of imagination by trying to fit things into the word law or the category of law, which certainly could be expanded and ought to be expanded, but by trying to fit it into that category, it actually narrows the possibilities of governance in general.
So this is a massive debate about, I actually think there's a very, good case to be made that Indigenous folks ought to make different discursive choices, actually. And so I'm very, open to hearing this argument. I'm not all that sympathetic to the kind of walls that often positivists in particular want to build around the concept of law. At the same time, I guess so to my mind, the case for using that word, because of course, in terms of like the history of the term, it's all wrong as applied to Indigenous folks for the reasons I've tried to set out in the second conception. But I think, the reason why I argue for the use of the word legality as a way of understanding the lawfulness of what Indigenous peoples have and do, as opposed to the more common expressions, legal cultures, legal traditions, legal systems, is because those tend to be descriptive accounts. And I'm interested in an explanatory account that is like specifically justificatory, something that actually explains how Indigenous law got to be how it is, and the thing that sort of justifies it all the way down, right, to its first cause. And in terms of its normative force. So that's one part of the argument on the other side that I would want to make. And I think the other piece is that I also think I'm also keen to preserve use of the language law, because I think we sort of conflate two uses of it today. So there's the sort of conventional use, which, to my mind, the narrower use that positivists often want to claim. But I think we also use it in a much broader sense, where it means something like, and this is not carefully formulated, I actually sort of had this on deck to write a paper about this, so I'm just starting to think about it. But something like, it's the kind of normativity which is socially accepted as having the kind of force which in a hierarchy of forces we accept, right? Which will cut across difference and which we will buy into. And in that sense, what I've described is law. So it doesn't have those modal characteristics in the same way, but on a kind of functional analysis, it serves that same end. It actually, I mean, if we think of it as sort of securing the conditions of order, as opposed to something like mere ethics or soft law, or it actually does serve that end, even in the absence of those modal characteristics. And so on those kinds of grounds, to the extent that that's what, like, that law is naming the thing that serves that function, I think it is right to call it law. But I agree, this is a rich debate, and I would love to continue it.
Thank you. And the last question, Maya Luna, please go ahead.
Thank you so much, all the panelists, and thank you so much for staying behind a little bit. Sorry for being a black box. But my question is for Professor Allard-Tremblay. I guess maybe in this debate, I'm a little bit confused about the strict or non-strict boundaries between transformation and abandonment, especially as the debate and panel has gone on a little further. You know, are we looking to abandon maybe some aspects of liberalism, like negative freedom, like contracting, or are we looking at just abandoning liberalism entirely? Yeah, I'm really curious to hear what you see as like necessary for the transformation. Thank you.
Let me say right away that I do not have a complete account of what is required for transformation. However, I mean, I think that there are indications of how deep the transformation required is when, for instance, Glenn Coulthard says that for Indigenous people to live, capitalism must die. That would be an important transformation, but that's not in the constitutional aspect. But the questions of how to change our legal and political institutions, I mean, I'm not saying we need to flush down everything, but the fundamental assumptions of crown sovereignty, of exclusive territorial control are elements that would definitely need to be abandoned. And that would change the dynamic, that would transform the dynamics between Indigenous peoples and what is a settler state. So how do you transform a settler state into a non-settler state? How do you remove, as Christa noted, the eliminatory dynamics, but also how do you learn to become a guest on these lands as opposed to the master and possessor of these lands? That I think are the essential aspects of that transformation. Whether that requires a change of the civil law and the common law, that's beyond what I can say. But these fundamental assumptions definitely need to be questioned. Thank you.
I hope to add one brief comment before we end, but I've spoke a fair bit, I realize that. So I wonder, Christa, did you have something you wanted to say? So it's just a brief insight, but for me, it was a profound one. And sort of connecting to this question, one of the big things I didn't grow up on my reserve. Like, I came to understand all these things starting in my 20s. And in coming into the lodges in the way that I was invited, one of the things I came to understand, I reject the binary in a sense that Kant imposes. It's actually not the case that if not autonomy, then heteronomy. Like, we don't actually have to frame sort of freedom in terms of individual or group. This is like the great insight that Indigenous peoples have to offer the world, is that that binary is false. And we tend to think of constitutionalism, of political community, of law, from the space of the link. So it's actually like reasoning from relationships as opposed to individuals or groups. It's the link that connects. That's actually like the foundational unit. It's relationships themselves as opposed to the subjects within them. So I would go so far as to say that if we're actually taking our own epistemology seriously and, privileged to still be able to do that, most of us, like myself, are not able to. We actually don't frame purposes as individuals, but rather like as relationships. So anyway, I simply wanted to offer that.
Thank you very much, and thank you, Aaron. These are good closing words, I think, for our roundtable this morning. Please, everyone, join me in thanking our presenters for an excellent discussion, excellent set of ideas in today's roundtable on Indigenous constitutionalism. Thank you.